Well, hello there, and welcome once again to the Disability Law Show. Good to have you along, hopefully for 30 minutes. Stick around, lots to learn. John Scholes here. I simply host all the heavy lifting, and all the intelligence is right over there. Tamar Agopian from disabilityrights.ca. Always encouraged to reach out to Tamar and her team anytime if you have questions, if you got a little pain, panic, and strife dealing with that long-term disability insurer. That could be one heck of a mountain to climb, but she is your Sherpa guide in that regard. It's simple. It's a phone call, right? The phone call is free. The consultations are also free. Here is the number, 1-855-821-5900. With email, it's help@disabilityrights.ca. We always have a main topic every week, and this week, we love this one, Tamar, long-term disability appeals. It'll be a fact or fiction segment. One of our favorite things to talk about. Is James here somewhere hiding? Because he loves this topic as well. We'll get to that, maybe some phone calls from one of our radio shows. We got a full docket, as they say, but we always start off with a week that was. Something you want to bring to the table first, pal? What do we got cooking for this week?
Wow. Again, another really, really busy week. Yep. Lots of phone calls. We spend so much of our day talking to people about their disability claims. And so I really wanted to highlight a woman who contacted me who wanted to talk to me about her disability claim. She and her husband got on the horn with me. We talked for about an hour. And her situation is so compelling. We're in the process of suing the insurance company over this. So let me share with our viewers what her situation is. She's in her late 40s. She worked as like a data manager type person. I'm simplifying it a little bit, and I want to protect her privacy. But she was doing this job for over a decade and ended up having sort of one of these freak kind of accidents where she fell over something, injured her ankle, and then that started this long process of multiple health issues. She, after some time with multiple investigations, ended up getting diagnosed with something called complex regional pain syndrome, okay? And look, I don't expect you, all you lovely viewers, to understand necessarily what this condition is, but just that first word, complex. And this, of course, is beyond what most insurance adjusters who don't really have any medical expertise, they don't really know how to deal with these kinds of things. And I give her a lot of credit. I could tell after speaking with them, just even for 5-10 minutes, that they'd been super frustrated with dealing not only with the medical side of this health issue, but of course the insurance company as well, who had now basically said, we think you can go back to a different job, and ended up citing the very same job that they had already accepted that she couldn't do. So this was around the 2-year mark, of course. So if you watch our show, you know that these disability policies have 2 tests to qualify. The first part being, are you totally disabled from doing your own occupation? So for this woman, it was being a data manager. And then after 2 years, that test changes. And that's really a lot of the time where we see people getting cut off because the insurance company doesn't want you on claim until you're 65, especially if you're 46 years old. Mm-hmm. They're doing the math at $3,000-$4,000 a month. That's a significant exposure. So instead, they will do an analysis. I call it a bit of a sham, quite frankly. Well, they'll look at your education, they'll look at your training, they'll look to see what else you can do, and then they'll say, here's 2 or 3 similar jobs, and again, in this instance, the same job, and we think you can go back and do this work because you're not that cognitively compromised, your pain is not that bad, you are able to sit and you can be accommodated, and therefore we're going to cut you off. And here was the more interesting part, John, is that they actually told her over the phone, it's not really a cutoff. We're not actually really cutting you off. We're just giving you the opportunity to provide us with the updated medical information that we think we need in order to continue paying your claim. But in the meantime, we're going to send you a letter cutting you off. And so, exactly. I mean, it's absolutely laughable. And so when they contacted me, they were utterly confused. I mean, not confused enough, thankfully, to reach out to a disability lawyer to have the conversation. But I said to them, this is not a dressed up pretend cutoff. When you receive that denial letter, you are being cut off. When you're being cut off, it crystallizes, it formalizes your right to start a legal claim. And so do not listen to your adjuster who's trying to make you believe that there's another chance. And we're going to get to this later in the show about appeals. So let me not skip ahead. And just more to the point in this situation is, I think when you've got some complexity to your health conditions, in her case, she has multiple practitioners supporting that she cannot work, and you've got an adjuster who's not being totally forthright. This is the recipe for success in a legal claim against the insurance company. They are going to end up paying thousands of dollars, I can assure you, once I have that legal claim in front of that insurance company. And I point to the phone call where they said to her, we're not really cutting you off, and then send her that cutoff letter the very next day. Because there is a duty for these insurance companies to deal with you in good faith. They are supposed to be transparent with you, honest with you. They expect you to be honest with them, and so that's that mutual duty. And you can't always expect you're being told the right things, and most especially, read those letters carefully. If they're saying something that doesn't make sense, if it doesn't smell right, it means it's not right, and it means that you likely have a basis for a legal claim. So look, I'm all over this one. I'm looking forward to the opportunity of having a real conversation with the insurance company, and I'm glad that they reached out to me. But they're very frustrated, John, and rightly so. They shouldn't have to necessarily go through this process where they are being she's unfairly being denied. Husband obviously has been supporting her. They're concerned about their financial situation. And I've said to them what we say on all of our shows. We work as fast as we can. We work as effectively as we can to get a result for our clients as quickly as we can. And that's by leveraging these kinds of facts against the insurance company to get good compensation for our clients in a legal claim.
Well, I think a couple things that you brought up before. Number one, dealing with the adjuster. Don't be intimidated. I mean, people think that's the be-all to end-all, but adjusters generally have a stack yay high in their desk of claims. They're banging them off like crazy, so they're not really that in-depth. Number two, you know, when they keep throwing out this more medical documentation, you could have reams of stuff to them, but that's not going to matter. They're going to, and that's frustrating. People want to pull their hair out. And even your medical team and doctors end up going, what else do I got to give you,
Literally.
man? You've got everything. You've got what do you want?
And so let's start with your second point, because I think that's what is very indicative of her situation, is that she's got 3 different practitioners she's been seeing regularly.
Right.
They've all prepared reports. She told me they've all prepared reports. Insurance company has what they need to continue paying past that 2-year mark, and they're still burying their heads in the sand because, to your first point, they've got reams of things that they're looking at. I think they've got targets, most likely, that they've got to cut off these claims and move on. And when they see any level of complexity with that change of definition, they're going to say, hey, you're just not sick enough. You haven't showed us enough. So here's a denial letter, but prove to us that we're wrong. And I think that that's really the problem, both for the claimant and their medical team. And this is why I feel as though we are trying to combat these insurance companies one case at a time, because we want to be in partnership with their medical practitioners as well, who are exhausted doing reports after reports. We want to work with them and help them in understanding what type of information is needed by the insurance company. And I'm not sending updates every month, John. Like, that's not, you know, I'm not going to treat these practitioners or the claimants like these insurance companies do. We're being very strategic in the kinds of things that we ask and the kinds of things that we need. Because if all the medical is there, it's plain and obvious, automatic. Then I'm just issuing the legal claim and I'm having a phone call with the lawyer saying, I think you guys made the wrong decision here. 9 times out of 10, they're like, yeah, I think we should talk about settling this case, right? But we've got to get to that point to do that. And I think that in that process, people do lose hope. I think they do get
they're tired, they're worn, they're sick.
They're sick, they're tired, they're frustrated. And I think they don't see a lot of options at that point. And, you know, they were even like, well, should she be returning back to work? And I said, well, if the doctors are saying no, then no. And that's the end of that conversation. Let's start that legal claim.
PocketDisabilityLawyer.ca. Tell me about it. Do you like it?
I do. I really love this tool. I mean, it's so straightforward to use. It's another tool where people can go in and get free information. It's a drop-down menu, you know, no legal speak, very, very simple. And it's a starting point. It's a starting point for people to figure out, where do I go? You know, I've got a few questions. Maybe they don't want to go so far as to talk to one of us. Totally okay, though our consults are free. And if you want to go on the browser and click no and exit out, that's totally fine, completely anonymous. But at least then you get somewhere where someone's going to give it to you straight up. Because I can assure you the insurance companies are not, and they don't really want you to have this information. And so this is our goal, is to try and push all this stuff out, these tools, including this Pocket Disability Lawyer.
Phone calls. How do you get them on air with us? It's simple. You tune into one of our radio shows during the week, disabilityrights.ca, to find a station in your town, your city that'll carry a show. You can listen in, call in as well. First call for the show, Tamar, comes right now. Listen up.
I'm currently on short-term disability due to a visual impairment, and I've had treatments for that impairment, and my vision has improved, but there's still a disability. My family doctor has encouraged me to apply for long-term disability. If I go forward with this, but it doesn't go well for me in terms of the insurance company accepting my application, and I decide it's not worth it, and I want to go back to work, what should I be considering if I decide to do that?
It's a great question. Not the only time we've had that. What do you think, Pat?
It's really a great question. And so in my mind, when there's still ongoing disability, John, this is a medical question, whether someone should be returning back to work or pursuing long-term disability. This is not a legal question. So I know people come to us and they say, should I do this? Should I do that? And yes, we can guide you. But a lot of the times I'm sort of saying, well, what is it that your own doctor is recommending? And this caller is telling us very clearly, their doctor is recommending applying for long-term disability. So apply for long-term disability, do it. I think that it's too easy to say, well, maybe I'll try return to work, or I'm going to wait, or let me see if I improve further. In this case, it's a visual impairment. And I think the trouble with that is that you may lose time that insurance policies clearly have requirements for. There's deadlines in which you need to notify them to make a short-term or a long-term application. So make that application, get that decision. Even if it's a no, at least it's a no that we can help you with, as opposed to you never applied at all, so you don't even get out of the gates. So in my mind, when I listen to this call, that's the first point. The second point, a close second, is always follow medical advice. Whether you should be returning to work or attempting a return is always something that you want to do when it's a recipe for success. Okay? And that recipe for success is regardless of what the disability insurer is saying that you should or should not do. Let's not forget, it's in their best interest to have you return back to work. They don't have to pay you. They don't have to look at your disability claim. They don't have to adjudicate. It's great for them. But it can be very harmful to a claimant, especially something like a visual impairment. I mean, I don't have the full details, but when you think about something like that, if you've made improvements, it could be that, let's say you're on a screen all day. Maybe that's going to set you back in your improvement. And you don't want to compromise your eyesight, something that's so important, so fundamental, because you're feeling the pressure from the insurance company to have to return. There are options in situations like this, but those rights and those options only exist if you actually apply for the long-term disability benefit. So look, I think that that's one factor, John, and you know, the last thing I'll say is that if that attempt to return is made and the health issues persist, then there is a possibility of a recurrence clause, recurrence claim. These kinds of things exist in the disability plans, but you don't even get there if you haven't made that initial application.
Take a short break. Appeals, fact or fiction, main topic for the show. We're going to get to that momentarily on the other side as we continue more of the Disability Law Show. Stay with us.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back. Disability Law Show continues. John Scholes, Tamar Agopian, of course, a disability lawyer at disabilityrights.ca. Reach out to Tamar anytime. As she says, consultations are free. So is the questions. Quite simply put, 1-855-821-5900, help at disabilityrights.ca. Okay, main topic. We love this one. LTD appeals, fact or fiction. This sticks in your craw, you and James, all the time. The appeal thing is such a nagging issue for so many people that watch the show. Number one, you must appeal a denial through your insurance company before taking legal action.
Fiction, fiction, fiction.
Big time.
You know, and I think what bothers me about it is the way that these disability insurers will write to you and suggest to you that you should appeal or that you must appeal before you get to the point of this legal claim. I've even actually had people contact us saying, hey, I'm unionized, I consulted my union about the denial of my claim, and my union advised that I had to appeal. And I can assure you, in all of the claims that I've seen and all of the policies that I've read, there's maybe one instance where the appeal was actually required. Generally speaking, folks, it is not required at all. The moment the insurance company says no to you is the moment that you have a right to pursue that legal claim. And quite frankly, you should. And I know we're going to talk about it, and I don't want to get ahead of myself, but the challenge with the appeal is that you're asking the insurance company to pretty please look at all of my same information that you've already concluded wasn't enough to either approve my claim or continue my claim. It's human nature that they're going to continue to say no. But when they write to you, they'll give you their full explanation, and maybe at the back end of that letter, maybe page 4, page 5, is where they'll put in that you have the right to pursue a legal action against the insurance company. But that's at the very end of the letter, after they've told you, but if you disagree with us, you can appeal. And so jump to the end, give us a call, let us help you.
It's that word, they love that word appeal, because people hear that, they think, and keep in mind this is all an internal process, they think appeal, it's like Supreme Court of Canada, it's going to an arbitrator, this is unrelated to the insurance company. No, it's not. It's like a yo-yo, it just comes back to them every time. It's their appeal.
It is. It's their process.
Right.
It's a sham, quite frankly, because it's not like they're actually putting fresh eyes on it. I've even seen some adjusters who will take different adjudication measures. So like that will be the time where they'll start to refer it to like a consultant for review or doing other things that quite frankly they should have done the first time around. So why give them that opportunity? You know what ends up happening, John, and I know our viewers don't necessarily appreciate this. And so let me pull back the curtain, because I used to work for one of these big bad insurance companies. Usually you have an adjuster who's assigned to your claim. That adjuster will review, they will issue the denial letter. You appeal, it usually goes right back to the same adjuster to review it. They may have another set of eyes, you know, over that cubicle, maybe a phone call to the supervisor, but otherwise, that initial level of review is the same exact process. They may have some certain tools, but those tools are not necessarily going to change the answer. What ends up happening in these claims files is that it gives the insurance company an opportunity to get more support, to get more emboldened, as they say, to get stronger in their denial. Why give them the chance to do that? Why allow them to spend time that's being wasted, where they're not paying you anything, to allow one of their doctors to look at it and then issue you another denial letter? And I think that's really the biggest problem with this appeal process, is that there's no transparency. You assume that it's going to be someone different looking at it. You assume they're going to give you a fair shake, but none of that is actually happening.
Assume it's going to be one.
Well, so that, I think, dovetails really nicely on point number 2.
That is, and filing multiple appeals increases your chances of getting benefits. The definition of insanity, right?
Well, it is, because it's meant to frustrate you, right? And so they will write to you and they'll say, this is our first level of appeal. And then they will write to you again. And then they will say, this is our second level of appeal. But this is our second and final, or maybe we'll give you a third level. And I've seen people go through appeal after appeal. Oh, it's going to work this time. Oh, I just settled one, actually. It brings to mind this poor client. He and his wife went through, I think, 2 or 3 appeals before they finally retained us. And they had been at it for a year. Wow. 12 months of multiple appeals, because they kept dangling that carrot to these poor individuals to say, oh no, but just get us another report from this doctor or this therapist, or do this and do that. And they did all of those things quite beautifully, may I add. I give them a lot of credit. But the result was exactly the same. And they lost a whole year of income, a lot of frustration. And this can be my problem, myself, my team. You know, it doesn't make it any better if you're going to continue to be in their process. It actually takes it out of their hands. I say this during our ads and everything else. Let us take care of it. We use the legal claim effectively. It puts pressure on the insurance company. It takes it out of the hands of that adjuster who said no to you once, twice, 3 times over. And it puts it in the hands of their legal department and a specific representative at the insurance company. And you know what's good about that is that they'll have to look at it with fresh eyes. They're forced to. And oftentimes that's what they say to my clients when we're sitting down and we're doing a mediation or a settlement meeting. They say, oh, well, we looked at it with fresh eyes and, we think that we can resolve this claim with you. Yeah, no kidding. Because they didn't go through 17 appeals, or maybe they did, but they actually used the law and the legal system to their greatest advantage. And that's really the key here, John, is that they're giving people a route, but they're not telling people that that route is not the recipe for success. It's just giving the insurance company another opportunity to say no and another opportunity to say no in the hopes that you're just going to go back to work or just give up and just forget about the whole thing.
LTD appeals, fact or fiction, number 3, final one. There's a time limit to take legal action after your claim is denied or cut off.
True. This one is a fact, right? And it's a hard fact. It is very clear that in most of the jurisdictions that we operate in, that time frame is 2 years. Now, let me be very, very clear about this. It's 2 years from the moment you are first denied. So don't wait. This is why they want you in their process with these multiple appeals. They want to run down that clock so that by the time you get around to maybe hiring a lawyer and starting that legal claim, perhaps you're out of time. And why is that a problem? Is because the courts will say, sorry, you're too late. You have missed the limitation period to sue against us. And I think that's really the biggest issue here, is that people confuse that 2-year mark. They think, oh, 2 years of change of definition, 2 years. No. This is a period of time in which you have to start that legal claim. And I know 2 years seems like a long time, but it's not. It goes by pretty darn quick, especially if you're taking a year or more to fight the insurance company yourself. If we start that legal claim, we'll be done and resolved within 10, 12 months. We'll be done before that third appeal decision letter is out. And I think that's the thing that people need to hear from us, is that we work quickly and effectively to get these results for people in that legal claim.
We will grab another phone call after the break. In the meantime, again, the number to reach out to Tamar and team, 1-855-821-5900. Back it up with the email, help@disabilityrights.ca. More coming up. Stay with us.
People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back to the Disability Law Show. A few minutes to go. Again, disabilityrights.ca to find a radio station in your locale where you can listen to our show weekly and call into it as well. Here comes that second phone call. Tamar, let's have a listen.
I've been on LTD for almost a year because of chronic back pain and mobility issues. I just found out my insurance company hired someone to spy on me. They sent a letter saying they have photos and video showing I'm more active than I claimed. I was just doing basic things like getting groceries, but now they're saying I'm not really disabled. Can they cut off my benefits over this? What should I do?
Ooh, we haven't had a surveillance chat in quite some time.
I think this is even more my favorite than even the appeals topic. I don't know if it's possible. Look, and I think the key really right out of the gates is to sort of say to people, it's not as common, right, John, as I think people feel it is. This idea of being spied upon or having an investigator look out for you. Look, insurance companies do it, but they do it only if it's going to cost them, well, it's going to cost them money, so they're reluctant to do it. But they really only do it if there's no other way to try and disprove your claim or shake you off claim. And so, as our caller tells us, though, she's not doing anything significant. She's not bungee jumping. She's not, lifting weights. I mean, it's fairly innocuous things, so day-to-day things, which I suspect she's reported to her doctors and probably reported to the adjuster at some point that really aren't working against the back pain and the mobility issues. But I think the key really is that consistency. So I want to see this denial letter. What is it that they're saying to her is so different than what they observed? And is it really that different than what maybe her doctors and practitioners have suggested? Because let's not forget, when you've got these kinds of conditions, one of the pieces of advice that you may get medically is you got to get out there, go and be active, go do routine activities to try and, keep yourself mobile and as best as you can. That's not offside. You don't have to be laid up in bed every single day in order to keep getting your disability benefits. So if you get a letter like this where there's potentially surveillance, I've even seen social media posts being scrutinized by adjusters. We deal with these cases all of the time. It is not a barrier to be successful against the disability insurer when they've relied on this to deny your claim. And so yes, they can cut you off on this basis, but should they? Is it a sound basis for them to do that? And I think this may be one where a follow-up call might be necessary, John, so I can have a conversation with her and say, look, have you been consistent in what you've been reporting? Have you been honest and forthright with the insurance company? I suspect yes. And so you're being met with, I find generally insurance companies and adjusters can be very cynical. They feel as though everyone's trying to pull a wool over their eyes and it's not really true. I think if there are medical bases for certain restrictions and then endorsement for other activity, then the surveillance really, it's not that probative, it's not that helpful. And courts have even said as much. The more recent decisions on surveillance, the big famous one is this Baker and Blue Cross that came out in Ontario a few years back. The court blasted the insurance company saying you did hours and hours of surveillance and none of it was helpful to our decision making, and they found in favor of the claimant in a situation like that. Now look, those were extreme circumstances and it's an extreme case, but it is truly the example of what we see a lot of these adjusters doing, which is it's a one-size-fits-all. We can't figure out another way to shake this person off claim, and so we're going to put an investigator and we're going to do whatever we can to try and put this into a denial letter and cut this poor person off.
And I think people need, to your point, need to keep that in mind. Sometimes with hours and hours of surveillance footage, it can bite them in the rear end because it might bolster your case and say, look, they're doing exactly what their medical team should. Oh, they're swimming because they were advised to go swimming. Oh, they're lifting or doing this. Yeah, the days of bed rest, they're like bloodletting. Those days are gone with physio.
Absolutely.
Coming from a friend of mine who's a chiro and physio, it's all about getting up, to your point, getting moving.
Right.
So don't fear it if you're doing what your medical team says you should do.
100%.
Right.
And I think that really is the missing piece when these adjusters are reviewing these kinds of chronic pain type claims, is that they are not staying up with the times in terms of what those recommendations are. And how does that align with them trying to assess, oh, well, is this person truly being truthful with us? They often think this is a smoking gun, but it's absolutely not. You're probably just confirming what it is they've already reported that you're doing. And oftentimes, by the way, when we start this legal claim, we'll get complete disclosure of all the documents, all the videotapes, all whatever it is that they have. And we usually see that there were multiple days where they didn't observe the claimant at all. So they might have done surveillance on this poor woman maybe 3-4 days, and maybe they saw her one day going out grocery shopping, and they're like, okay, we're going to use this one day to deny the claim. So the proportion really matters, the consistency of reporting matters, and whatever is being medically required and suggested is also very, very important, and of course forms the basis of that legal claim at the end.
We're out of here in a minute, but quickly, anything anybody should remember if they think they're being surveilled? Just go about your life, right?
Look, absolutely. And quite frankly, if you think you're being followed, I'm more worried about people's safety and security in this day and age than anything else. And so please do report it to the police if you're not sure if there's someone suspicious. And I also think be mindful of social media. Privatize that stuff. Don't post things if you don't need to. Everything can be taken out of context. Don't give your insurance company more ammunition than they are looking for.
And a good way to wrap that up. Appreciate the letters, the phone calls, and everything else, the correspondence every week on the show. Keep it coming. Reach out to Tamar and team. Consultations won't cost you a penny, right? 1-855-821-5900 and email help@disabilityrights.ca. We'll catch you next time in the Disability Law Show. Thanks so much for watching.